Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. I love it. I love it because when you're hosting these StreamYard live streams, you can actually see all of the people that are backstage. so while watching this introduction with the music bouncing, like I can see Kurt just kind of jam into it.
Yeah, I'm psyching myself up. It's a banger, man. It's a banger.
Yeah, right. It's that's why I chose that music. Is like it's kind of upbeat. It's like, all right, let's go. So because the
law's fun, and if you disagree, you suck.
Well, also for me, like I don't know about you. Like you always seem very, very chill on all these live streams, but
do I though?
I've gotten better, but I feel like I still get very nervous before I start these, especially if it's just me. So for me, like it's very helpful to have like a minute of that background music. We all have our
weak spots. Like the nervousness is not an issue. Like there are other issues that I could describe. Maybe off camera, we'll point out to my weaknesses so we don't make it obvious. But yeah, there are definitely things that are where I'm weaker that are okay. Pressing on.
Yeah, no, but for me, and then it's like I'll finish up a live stream and then Mr. Bites will walk in and be like, you've got to stop saying and like you keep doing that, like it's distracting.
We all need to do that. And Mr. Bites is right, and I do it myself, and I should know better from a Toastmaster. If you've ever been to a Toastmasters meeting, which is a wonderful way to learn to do public speaking, by the way, if you're interested in public speaking, it's very, very inexpensive. Toastmasters clubs are everywhere. Great way to learn public speaking. But one of the roles they have is the and ah counter, and they literally count. And at the end of they ask for a report. It's like, well, Legalbytes used or ah 13 times, and
it would not be 13.
And like,
it would be like Legalbytes has a new record, 1,525.
Well, once you're conscious of it, once you know that someone is making note of it, you do learn to control it pretty well. So. But I haven't been in a Toastmasters meeting in a while, which I think is evident from my and ahs counter, which is not looking great at the moment on my channel either. But Mr. Bites is in fact correct. So point to Mr. Bites.
Yeah, no, for sure. So anyhow, so that intro is always great. So for anybody that is listening on the podcast version as opposed to watching this on YouTube, I have with me Kurt, also known as Uncivil Law.
Yes.
And joining us will be Nate the lawyer. He said he's just a couple minutes behind. And I'm sure, and Joe Neerman, also known as Good Logic, he will be here also, he said. But, his tendency is like on time is like 20 minutes late. So so we'll probably see him, at some point later in the show, he'll pop in. So we have some really interesting, and then there I go. I already broke it. I already said and again, shoot, there we go. So I will just take a pause and think about what I'm going to say instead. We have a lot of very interesting topics today. Some of those including, now I'm really paying attention to it, and I see somebody in the chat is like said 7 in the past 20 seconds. This is really hard, and I feel like it's even more distracting when I'm paying attention to it.
we could get out the bell, and I'll just hit the bell every time you do one.
Oh, that would be awful. That would be so awful. So we have some very interesting topics today. One of them is a sort of
recap of yesterday, where I went through the motion for summary judgment in the Depp v. Heard case, Amber Heard and Johnny Depp. That's a very, very interesting one. Another one is so I kind of wanted to discuss it with
people. Natalie Wilco becomes a member. Hello, Natalie Wilco. Thanks for becoming a member of the channel.
Natalie Wisco. Welcome.
I call her Wilco.
Yeah, you did. That's okay. But I corrected you. It's okay. We can smooth it over.
No, your name is right there. And I've heard it pronounced.
Natalie, thank you so much for becoming a member. You're so awesome. And I really want to have you on the show again at some point soon. So I was just thinking about that earlier today. So we've got to DM and see what your availability is if you want. So also, hey Nate, how's it going?
Yay! What's going on? My favorite people.
How's it going? So I really like your new background. It looks like you've got a nice green screen.
That's an interesting way to go. I think that's an interesting idea. Put the thumbnail for a recent video on behind you. I might steal that idea. That might be a good idea.
It's not a bad idea. So for anybody that is listening that cannot see this, Nate just popped in and he has behind him his thumbnail for his upcoming live stream today. That is the sentencing hearing for Jussie Smollett. Juicy. So very excited. I really want to join you on that one.
A year and a day or bust. That's what I'm going with. I'm not going to be happy. Yeah, I know I'm not going to be happy, but I can hope.
He's not getting any time, brother. He's not getting any time. He's going to be walking out of.
But he deserves it. He almost started a racial war.
That's yeah. And you know what? I'm going to say it, even though this is probably going to be canceled. So it's past that point. But he had everything going for him. He was gay. He was black. Like, he checked all the boxes. He was on a hit show. It's like, what? It's like, why make this lie? It just doesn't make any sense.
It is interesting when you see people who are successful who lie. Let's see, there's one for me. You see that in speed running, for example, where people try to beat video games fast, and there are people who are actually very good, and then they hit plateaus and wind up cheating to even get more. Mm-hmm. So it happens to lots of people in lots of different fields. So
I wonder in particular in Hollywood if it's just that kind of environment that if you have that momentum, then things are good. But as soon as you start losing that momentum, you can just drop off a cliff. So maybe some people just kind of panic, and maybe he panicked.
Hollywood is definitely a drop off the cliff kind of town, it seems.
Yeah. Because you could have somebody that's on top of the world seemingly, and then they get an Oscar, and then they've got some bigger movies lined up, and then all of a sudden they make a few poor decisions, and then just they're gone. That seems to happen quite a bit.
Yeah.
So
Pauly Shore was talking about that when he was on Joe Rogan Experience.
Oh, really?
How he was the biggest thing in the world for a moment there, which was pretty true. And from a bad decision or two, basically drops off the face of the earth. And he was talking about how he sometimes is on set to visit somebody or whatever, and he basically regrets the fact that it's not him anymore. And so the world can be a cruel place.
Yeah, no, for sure. And
but the law isn't cruel. The law is great.
The law is very
It'll be
legal mindset will be here.
The law will be there in your time of distress.
The law is a very tricky beast sometimes, because sometimes it's I don't know, very, what's the word for it? Just very poetic. Like it'll help people that help themselves. But then sometimes it's just people will lose on a technicality, and things are a decision is made that it has some disagreement, so I don't know, but it's the law.
I don't always agree with myself. Which one of the reasons I do my show, because sometimes I'll listen back to myself. I was like, I'm not so sure about that one.
So let me get a couple super chats, and then we can get into some of this substantive conversation. Warren Lee says, drinking game, or oh my goodness, you'll be I'll get you guys drunk in 2 minutes because of my ums and uhs. And Nate, Prison country.
This is prison country.
Prison country.
One can hope. If justice is kind.
Yeah, first-time offender. You really want this first-time offender?
He tried to start a racial war. He's not just any first-time offender. He tried to start a racial war.
Yeah,
it's a little bit different than your typical first offender, Nate.
10 years in prison for your race war.
Yeah, a little bit. When you're trying to start a racial war through your lies, that's a little bit more aggravating in the technical sense of the word aggravating than your typical offense, Nate. Yes, I think that should result in a sentence enhancement, Nate. I think that's a guidelines departure moment, Nate.
Race war. I don't know, bro. I think you're
really
being a little too cruel to the
Legalbytes. Tell me I'm wrong. You're not doing a guidelines departure on this one.
I do want to say one thing though. The thing that's pissing me off is the NCAA, Black Lives Matter, Jesse Jackson, Samuel L. Jackson, them all come in and saying that he shouldn't get any prison time because he's a good boy. It's like, this is ridiculous. This guy, like you're saying, he did try to start a race war. I think that now it's starting to get ridiculous. And you know what it does? It makes people think that these organizations just see race instead of seeing what actually happened. This guy lied to everybody, and the people he most affected were the black people, right? Those two Nigerian brothers, they aren't white guys, they're black people, and they almost went to jail for this. So I think people, it's funny because we argue about white privilege all the time, but this is celebrity privilege. Because if one of you guys get caught up, ain't Samuel L. Jackson and the NCAA writing a letter on your behalf saying this is your first time, they should go easy on them, right? So this, it's all BS. I'm sorry about my rant, but it just really
I might get the ACLU on my side since I'm a woman, but maybe.
That's true.
But that's another. Realistically, I doubt that would actually happen. Just because I'm not the type of, I guess, person that tends to find support from the ACLU. Let me get a couple more super chats. Andy the Game Maker, thank you. He said he was also a mighty duck. What do ducks do? Fly together. Quack, 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 quack.
They also
I appreciate you.
There's other things that ducks are known for.
Your non-response. Sorry, Kurt. What did you say?
I was just saying there's other things that ducks are known for. Certain unwelcomed assaults. Ducks tend to assault other ducks in unwelcome, purient ways. No.
I'm not sure.
You're at another level, brother. You're at another level.
The raping. Ducks rape ducks. They rape.
Do they really?
Yes.
But is that considered?
That's the whole thing with the corkscrew penis and the corkscrew vaginas. This is too much anatomy. Okay, never mind.
You've convinced me.
Alrighty.
Life is like a hurricane here in Duckburg.
Warren Lee says,
DuckTales?
Yeah. Life is like a mystery. Rewrite history.
Hang on, let me get a couple more super chats here. Warren Lee says, Nate, as I understand it, this is his second perjury-like charge that he's lost. Is that the case? Do you know?
I think there was like another something that happened in the past, but I think that was like dropped or something like that. I know he was there was like another something he had, but it's listen, it's when judges start sentencing, you go through what is it called, the four theories of punishment. You might have heard them,
specific deterrence, general deterrence, retribution, isolation, reciprocity. I got 5.
There are there's 4 main ones, and there are bridges between them. But when you're going through it, here you're talking about what justice would it be to make him go away for a year? Maybe you're really only talking about rehabilitation or not restitution, but retaliation in terms of making him pay for his crime. But I still don't think you could treat him differently than you treat anybody else, because there are a lot of people. If we're locking people up for lying to the police, we'd have a lot more people in jail.
Again, it's everything in law. Well, I used the word like everything, which is a mistake. You shouldn't use words like always or never. Law is often fact specific, and especially when you're coming to sentencing. you can look at the specific facts. Not all crimes are created equal, even within their own terms. And one of the things that you have to consider as a judge is the nature of this particular crime. And that can wind up in upward or downward departures. So the fact that he lied to the police by its own terms puts you into a certain box based on the nature of the offense and so forth and so on, at least under federal law in terms of sentencing guidelines. I assume Illinois is at least comparable in some sense to that. But then from there, you have to consider the seriousness of this particular crime, for better or worse, right? Maybe this is kind of a no harm, no foul kind of thing, and we should be more lenient. Or maybe you try to start a racial war, and I should nail you to the wall. So that's where I'm judging this based on its own terms, at least in my mind. And I think nailing to the wall because of the racial war is, pretty good reason, in my humble opinion, as theoretical jurist. Overrule me, Court of Appeals, Nate. Overrule me. Say it's abuse of discretion. That'd be good.
Yeah, it is. It is true that the circumstances of the crime itself will determine whether the sentencing gets a leg up or a leg down, right? So, for example, with Derek Chauvin, the fact that it was it occurred in front of minors, the fact that he was a police officer, like all of those things are things that can either enhance or bring down the charges. And I don't know, it'll be very, very interesting. But if anybody wants to actually watch the sentencing hearing, where can they watch it, Nate?
Oh, 2:00, my channel. We'll be on it.
That'll be 2:00.
Yeah,
Central,
if we go to either. Well, actually, it's 2:00. Well, I'm starting 2:00 Eastern, and the sentencing should be 3:00 Eastern. So, and that's just so you can talk track and watch the news media go crazy over it, and then we see what happens with just Jussie. But I think it's going to go about an hour because they first had a motion to set aside the verdict and all of the stuff, and then they go on to sentencing. So,
yeah, for sure. So that'll be super fun. I plan on joining you on there because I think that'll be very, very interesting to watch, especially because they didn't allow cameras in the courtroom for the actual trial itself. Yeah. So that'll be really good.
But
so if you guys are
sensing, which seems slightly odd, but okay.
Yeah, it's a little different, a little interesting, but there you have it. Let's see. And I just realized, so I thought I put the link to your live stream in the description, but I didn't. I put a space for it. I didn't actually put the video link in there. So I will update that as soon as possible. So you guys can go and just click on the link from here. That'll be great. So a couple more super chats. In Fantasy I Die said, Kurt, do you have a last name or are you an artist like Prince or Madonna? I just call you Kurt Angle in my head. Bites. Looking forward to your coverage of the Depp trial. Nate, MAGA country. So, for the Depp trial. Well, sorry, what's that?
No, I said when you say the MAGA country, you got to say it with the Nigerian voice. You got to deepen your voice and then have the Nigerian voice.
You're the only one who can do that.
I know. Yes, I was just gonna say, if I do that,
MAGA. Like she's like. She's like MAGA country. No, MAGA.
Someone is going to clip me, a very white woman, doing that, and it's going to be like, "This chick is racist."
We live in a woke world.
I know. It's just it's being canceled is a thing, and.
Yeah, I'll check this out. The the stupid thumbnail, right? They said my thumbnail about the live stream was homophobic. I'm like, how the hell is it homophobic? What are you talking about? Because it had the two Nigerian brothers with their hands raised. I'm like,
it's a real photo of them.
Yeah, they're not even gay. What are you talking about? How can it be homophobic? I'm like, you guys are just looking for anything to just, it's like, this is starting to get ridiculous now. You know what I'm saying? I can't use a photo that they took, and it's like people are just insane now with this stuff. So whatever.
Yeah. Anyhow, but yeah, no, that's ridiculous. If it's an accurate photo, it's a real photo. Whatever, who cares? Hunch the Dirty Roofer says, I'll say it again. I want Jussie to attend the police academy and do 6 months on beat patrol. That would actually be a very interesting kind of punishment. Very creative. And I think that would be something where he could maybe actually learn something. Maybe.
But how does he pass the background check though? You can't just
yeah. That's a good point.
Be a cop. Well, yeah, he's been convicted of 4 felony counts. Don't put on a badge and go protect and serve.
Well, I don't think that. Well, he would probably have to do it under. I mean, kind of it's like similar.
Do it under stage name.
Under a stage name, no, but I wonder if it would have to be a similar situation to like a law student going to law school and then getting a summer internship, right? Like you go, like you don't actually practice law, but you do the law practice stuff under a licensed attorney and you just kind of work for them. Like he could just kind of be like a ride along or something for 6 months and then learn what they learn and that kind of stuff. Maybe, I don't know, without actually getting to walk around and present himself as a police officer. That'd be funny.
If he wants to wear a sandwich board saying I'm a dipshit, I'm in favor of that. That'll work for me.
If he what?
If we want to punish him by making him walk a beat wearing a sign, wearing a sandwich board saying I'm a dipshit, I could go for that. That'd be fine.
Cruel and unusual, baby. Even though that's what they were doing in California for a couple of years. That was fun. Always funny to watch.
Oh yeah? Wait, when was that?
Remember the judge was sentencing people to hold the signs like I like to steal food or I like to do this and they would have
an Eighth Amendment violation. Is that an Eighth Amendment violation for cruel and unusual?
But people were taking it because they're like, you do that or go to jail. And people were doing it. Judge orders people to hold signs up.
Yeah.
Interesting.
Works for me.
That is interesting.
You guys have never heard about this?
No.
I've heard about it.
California.
Well, I've heard about it. More than know than
Let me see if I can find it. All right, here it is.
Making people wear a sandwich board saying I am a thief or something like that. Yeah.
Yeah. But this one is from. Let me share the screen. So here is one from Missouri. Seems like judges all over the place are doing this shit.
Oh yeah, like it's not a California specific thing. I've heard of it otherwhere.
Here it is right here. This is Fox News. A judge orders criminals to stand on the corner of shame holding signs instead of serving time. Won't come to court. Won't pay my fine. So judge ordered me to hold this sign.
Oh man.
Cruel and unusual? Is this cruel and unusual?
I mean, how long was he making them do it?
I'm not sure. It's just
the modern pillory. What's wrong with the pillory, man? The pillory is great.
I'm thinking
bring back the pillory, man.
Maybe a couple of days or something. I'm not sure. It doesn't say. Thanks to new
policy. We're not even putting your hands and head inside a lock piece of wood and making you stand there, from sun up to sundown or anything, man.
Damn. Yeah, this guy's screwed. Man, but funny. So there's a whole bunch. I mean, I steal, I do all that stuff. So yeah, so these people that's unfortunately hilarious. But this wouldn't be cruel. It would be unusual. But yeah, I think it would fit under because it's cruel and unusual.
Yeah.
So you could do something unusual. But
no, I think it's the modern version of the pillory.
It's definitely unusual. That's for sure.
I'm not sure the pillory is cruel and unusual. I mean, at least in the classic sense of it, because we have to, at least to my mind, right? We go back to the time of the words when they were founded and what was cruel and unusual. And there used to be pillories up and down the streets, and so I don't think it's cruel and unusual. So it's just the modern pillory. It's fine, right? It's all good. All good in the hood, no problem. What else you got?
Tar and feathers.
Tar and feathering might be a step much.
That yeah, because
I'm not sure the tar and feathering was recognized at common law as a lawful punishment.
Yeah, I've never read any court opinions talking about a tarring and feathering.
Yeah.
Usually wasn't that mostly done like around wartime? Like I know in American history, like the Revolution, that was a thing. They would tar and feather Tories, which is kind of a little bit of a
I think one of the British
dark part of
British person. Yeah, I think like there was a British guy in England that was here right before the Boston. He got tarred and feathered like 2 times in a row, and so like he got tarred and feathered and like brought him back a week later and tarred and feathered him again. We really hated the British back then. So
Man. All right. So Warren Lee says, okay, last one, darn it. 2017, nolo contendere, fake ID to police officer DUI charge, followed by signing a court summons with brother's name check. Wiki. Huh. Interesting. So, but was he actually convicted or?
Well, that's it's what's the nolo contendere. That's the
no contest.
I mean, no contest.
Yeah, no contest. So that's we call them Alfred police here. But fake ID, police officer DUI, I don't think that's going to change anything because number one, I'm not sure if this is a felony or misdemeanor, which would also matter, and and sometimes also too for those of you who don't know, a lot of times with misdemeanor convictions, they get erased like we do here in New York. I can't speak about other places, but we here in New York. After a certain amount of time, you can go and get that expunged from your record or removed from your record. So, and I don't think the court's really going to take this into account. A 2017, fake ID charge and say, give him 5 years because he showed a fake ID to a cop one time.
Yeah,
no, that won't do as much for me in my sentencing memo as the racial war will.
Yeah, I think the race war would definitely.
The race war is definitely going to make a prominent feature of my sentencing memorandum.
Yeah.
Yeah. As I sentence him to 5 years.
Because I mean, you
hard
think about
labor.
You think about somebody giving a fake ID. I mean, that's like, you could go to, downtown Austin, down on 6th Street. I'm sure there are plenty of college students that are giving a fake ID.
No. Why would you say such a thing? Why would you besmirch the name of the college students who want nothing more than to study and to better themselves?
Because I went to school in that town, not undergrad, but law school.
and are you saying that some of your friends were such miscreants?
No, because everyone was actually, correction, most people were over 21 by the time they started law school. There was one of my classmates who started his 1L year as a 19-year-old, which is very, very interesting. But he was a cool guy. Really liked him. But anyhow, everybody else, I think he just didn't go to the events that involved alcohol.
Which is all the events in law school.
Yeah, which is like everything. Yeah.
Yes. I mean, basically every event that's not during class hours.
But let's just be real. Undergrad, though, if I had my first beer way before I was 21, right? So, yeah, if that's the case.
Yeah. All right. If Smollett Matt Hagen says, if Smollett had to ride along with cops, how long would it take him to lie to the cops about planting knives on people? I don't know. Is that a thing that he's done?
I don't know.
Okay. Anyhow, Mad8 says, I served in the Navy with people that were told Navy or jail. Oh, that's interesting.
Yeah, I think that's more of an older thing. I don't think that's as much a thing today, but I believe if you're saying like 1970s, I believe that.
I mean, I think that I don't know if that's in any active practice now, but I think that is for some people maybe very beneficial.
I would think the Navy also might have its own objections to this, incidentally, because this is a purported criminal, and the Navy does, of course, do background checks as well. So this assumes the Navy would want such a person.
This is true.
It's that conscription, like for Vietnam. It was that conscription for World War II. So it's kind of like that side conscription thing where you got arrested. Well, you can go do 5 years, or you can go serve your country.
Go to war. Now that's even more.
And that one, the prisons,
because that's not just normal service.
And that one, the prison's looking pretty good. I don't know how many people went this way in the Vietnam War, because this is one of those questions that I have a bit of a blind spot with. But I would have to imagine that. I mean, obviously there were people who just dodged the draft, people who fled. But I have to imagine that there were people who would be like, just arrest me. I'm not going. I'm not doing it. Just arrest me. Throw me in prison. Screw you. And I don't know. I wonder how many people just went to prison rather than go to Vietnam. Because I don't know, man. If it's if it's me, and you're like, okay, you're being compelled to go to Vietnam and fight, and people are going to shoot at you and they're going to kill you, or like, okay, I'm actively going to disobey your order, so you're going to put me in prison. So the prison sounds pretty good. So I don't know, man. It's like, okay, where would you like me? Which prison would you like me to turn myself into? You know, it's like, I don't know.
Yeah, for sure. See Goody, hey, thanks so much for your super chat. He says, I almost feel bad for all the BS I give you. So here's a 20, put it towards a good sense of humor. I think we're even. Oh, that is really kind of you. Thank you so much. So for anyone that doesn't know, See Goody used to be a moderator in my chat, and he has a very strong sense of humor, and I don't mind it personally. I don't mind anybody. To be honest, in the chat, I generally speaking kind of am relatively laissez-faire about people making different kinds of comments and different kinds of jokes. But the problem with having somebody that is a moderator with a strong sense of humor is that other people started to think that I was, in a sense, what's the word for it? Endorsing that stronger sense of humor. So if anybody has been curious about what happened, because every time I go into Nick Rekieta's chat, See Goody likes to give me a hard time.
He gives me a hard time too.
He gives me a hard time.
He gives everyone a hard time.
So, but there's no hard feelings there. I just unfortunately had to decide that because I started to get people sending me screenshots of different comments and stuff saying like, you know, these were people that were paying members in the chat that were talking about how they were going to leave, and you know, and then other people that are actually close to me in the real world that are like, what's going on here? Like, this looks bad. So I hope that there are no hard feelings on your side. There are certainly none on mine, and you can say whatever. You can come in anytime you want, See Goody, and chat it up. No problem. No problems here. And I really appreciate the super chat. That's really kind of you. So, and Aaron Catron, thank you so much for your super chat. So I think we are.
One thing I wanted to also say about the chat thing is that I think people also have to understand YouTube banks us as creators for sometimes some of the chat stuff. So it's not really us moderating as much as we're like, you know, we don't want YouTube to, like Nick he got a week for that, right? Somebody put in his chat and he didn't catch it and he got a week for that. He was like, oh, but they gave him a week. So it's unfortunate, but we got to be careful ourselves.
Yeah, no, for sure. And that's the thing is that when it comes to that in the chat, I feel like it's an even stronger sort of hit that you can get if it's somebody that has a wrench. So yeah. So anyhow, but that's that. And I've never had any hard feelings about it. And I'm sorry that we don't. I don't think we have any connection on Twitter, so there's no way to have a conversation by DM or whatever. It's always via the live stream chats. So anyhow, yes, but feel free to come and hang out whenever you want. Ella, thank you so much for your super chat. Ella says, if you want a real military punishment, send them to the USMC, only for the toughest. I will say, I don't have anyone in my family that has served in the Marines, but one of my best friends from undergrad served as a Marine in Iraq before she came to college. And she is one of the toughest people that I have ever met. Toughest, smartest, coolest people. And I've always been totally in awe of her. And she is awesome. So I will second that. US Marines, only for the toughest. And actually, Mr. Bites, not being somebody who's in the Marines, agrees. He's told me, he's like, if we have kids and they want to serve in the military and they decide to go and be in the Marines, I'm okay with that.
Air Force or Coast Guard, I think, is the way to go. Air Force or Coast Guard.
You mean the
or now there's Space Force though. Maybe the Space
Force. That's kind of cool too.
Yeah, I like Space Force.
Forget the Marines. I'm all about the Space Force. Yeah. You know how hardcore I am. I'm you know how hardcore military I am. I'm National Oceanic Atmospheric Administration. I'm NOAA. I'm Noah military. That's how hardcore I am. Yeah, Noah military. Wah. I'm in the Surgeon General Corps, baby. Yeah. Hardcore. I'm the best military.
Matt 8 says, all I know is the people that were told to join the military or jail chipped paint. This was in the 90s. Okay, so yeah, if it was in the 90s and not during a time like Vietnam, that's a very different story, right? Because there wasn't too much going on by way of really any conflict, including the Cold War at that point. Okay, anyhow, that is all of that.
Since we have a break, could I suggest that we could do a bar exam question together?
Yes. So
and you, the audience, get to play along at home. We're going to do a poll.
Let's do it.
And I have to give you the options before you select A, B, C, or D, or you're going to seem like an idiot. All right. So she will put A, B, C, or D, but you probably want to listen to the question before voting. Just a thought of consideration there. And we're going to do a bar exam question together because that is fun.
Yes.
Would you put a poll in the chat? Put the poll in the chat for the question. Like
yes.
A, B, C, or D. Just A, B, C. Yeah, I'm asking you literally.
There's
there's a poll option.
Okay.
Literally just A, B. Okay.
Yes. So.
And I will read the question and we'll give you guys a chance to answer. And then we'll talk amongst ourselves and see if we agree. And then I'll give you the answer.
Okay. Which do you think it is? Okay.
All right. It's available so you can share the screen.
There we go.
All right. So I will read this to you for those on the podcast
People
or otherwise.
Already
can you make it a little bit bigger, Kurt?
Yeah, there we go.
All right. So here is the question. Well, that didn't really work, did it?
How is it already 50% D?
I figured about
I don't know. A borrower owed a lender $50,000 due on March the 1st. On January 10th, the lender telephoned the borrower and said he would discharge the debt if the borrower would promise to pay the lender $45,000 by January 15th. The borrower responded, I will attempt to get the money together. On January 11th, the lender again telephoned the borrower and said he had changed his mind and he would expect the borrower to pay full payment on March the 1st. On January 15th, the borrower tendered $45,000 as full payment, which the lender refused to accept. On March the 1st, the borrower refused the lender's demand for $50,000 and the lender sued for that amount. Which of the following statements best supports the lender's position? A, the borrower's January 10th statement was not a return promise and therefore the lender effectively revoked his offer on January the 11th. B, the January 10th phone conversation between lender and borrower created an executory accord and therefore did not operate as a discharge of the $50,000 debt. C, the lender's offer to discharge the debt was a gift promise and therefore was not binding on the lender. D, the lender's promise to discharge the $50,000 debt was non-enforceable because it was not in writing. Ooh. And I will let you ponder that.
I think I'm going to need to read through this one more time.
Yes, you can take your time.
Can you can't just make it just a little bit bigger? Oh, matter of fact, let me see if I can do it on my screen. I got it.
Hold on.
I can do it. I got it.
I got 100% to 200%.
No,
a little bit smaller.
Put it back to where it was for.
No,
yeah, that's okay. That's okay. Leave it there. Yeah.
Okay, so a borrower.
You got a lot going on here. Kurt, you pull the longest question. So obviously it's the contracts question, and we're talking about offer and acceptance, right? So
yes.
And we're talking about account.
There's multiple promises, right? Because there's the borrower has a promise to pay the lender $50,000. Then the lender also is saying that they would discharge the debt if the borrower would promise to pay the lender $45,000 by January 15th. So basically, he would get a $5,000 discount if. Okay, hang on. We've got one more here. Hey, Legal Mindset.
Legal Mindset. We're doing a bar exam problem.
We're doing a bar exam problem.
Oh my God, you're cheating on me, Kurt. You're cheating on me.
All right, I'll just run through my take on this. All right, so
okay.
So answer A, right? The bar 10 was first I'm going to eliminate B, right? And the only reason why I'm eliminating because executory accord. When I start getting things like that, which I don't know what the hell executory, I'm going to throw that out, right? Boom. Executory court doesn't make sense to me. So I could be totally wrong here because I haven't done these contract questions in a long time. That could be the answer, but I'm throwing it away. Now, my issue is that is there you have an offer, and what's his acceptance? Was his acceptance of the $45,000 agreement? Was that right? Because he had to know there was I think the offer was good, but really we're talking about the acceptance. If he accepted, if he had a proper acceptance, then paid him the money early, we're good. But if that acceptance wasn't good, then we don't have anything, and then you could go with the other one. So I'm looking for something like that, something that either says that acceptance isn't good of the offer, or something that says that the acceptance was good and for the $45,000. So I don't see that there, but the only thing I do see that's even close to that was that the January 10th was not a return promise, and therefore the lender has effectively revoked his offer on January 11th. That's the only thing I think makes sense based on that. But again, I could be totally wrong.
Yeah. So I'm picking the thing that I'm looking at most is the fact that it says on the second sentence says on January 10th, the lender telephoned the borrower and said that he would discharge the debt if the borrower would promise to pay the lender $45,000 by January 15th. So it sounds like he said on that day, on that phone call, he said, if you promise to pay me $45,000, not that he would discharge the debt if he paid $45,000 on January 15th, if he promised to pay. That's kind of what I'm focusing in on. And the borrower responded, I will attempt to get the money together. That doesn't sound like a promise to me.
So you're an A girl? You're an A girl, Legalbytes?
I think so. I think so.
You're looking at A with me. So you're just not a proper acceptance.
Yeah, I think so.
I just love like the incredulousness of D, where it's got to be the writing element.
Yeah.
Yeah, but that's my legs.
Yeah, exactly. It's definitely A is looking good here.
I think so.
Well, I'm happy to say that all of you got it right. The answer is in fact A. The problem is lack of acceptance, according to this. A is correct. By not returning an actual promise to pay the $45,000 by January 15th, the borrower's vague response to the offer of January 10th, although intentional, was not sufficiently promissory to constitute an offer and create a binding contract. So lack of acceptance.
And a plurality got that right.
There you go.
In the poll, 32% of people said A, 26% said D, 20% said B, and 20% said C.
Of law students, 70.5% of the people put A. So
law students suck. I mean, they should be getting that 100. I mean, come on, man.
They maybe didn't focus on the fact that it was a promise, not if he agreed to pay, because it sounds like, because if you miss that detail, then you might be thinking, okay, so he has an open offer that has not closed yet. Like the timing for him to respond hasn't closed yet. So therefore he still has until the 15th to respond by paying it. Right. And then, while that offer is open, then the lender's saying, no, actually I'm going to go away on this. So that I can see how people can get tripped up on that.
Yeah. But just so the chat understands, to have a contract, you have to have a clear offer and a clear acceptance. So if I offer, $10,000 for your car, and you don't say I accept that offer in a clear manner, then we don't have a contract. So, and that's what this question was going to. Even though there was a clear offer, the acceptance wasn't that clear. So the contract, so you didn't. So there was never a contract to hold anybody to.
Yeah. And there would be sufficient consideration because the $50,000 wasn't due till March the 1st. So the offer was, give me $45,000 on January 15th before it's due, right? So you're exchanging something, less money for an earlier payment. Both sides are giving up something. Yeah. There's consideration.
Yes.
Now, what's also interesting is that he attempted to accept by performance, right? Because he attempted to pay the $45,000. Acceptance by performance can be a thing, and would be sufficient to overrule the statute of frauds problem. The problem, of course, here is that the offer was revoked because he didn't accept prior. He didn't accept in time. Yes. So the offer was revoked prior to the time of performance or acceptance. And so therefore there is no promise. Therefore he can't perform on the agreement. Therefore A is the correct answer. So we all got it right. Yay.
Nice. Okay.
And we all learned a little bit of law.
I prefer when there's a loser.
I can find something where you get harder. A grandfather says, I bequest to my loved son as long as he's alive. Ooh. And then following that,
are we going to get into the rule against perpetuity?
Rule against perpetuities. Yes, let's do it. Let's do it.
Rap.
The nature of the will concerns a covenant on a piece of land that has also been subject to a recording error. Also, incidentally, someone else has been occupying the land for the last 9 years.
Wait, is this a real thing you're reading?
No,
right
I'm
now?
just making shit up to make it as hard as possible. I'm just like, how many
making
things
up a
can I
rap
throw into this
problem?
as hard as possible?
Yeah, recording error. I'm like, that's okay.
Recording error.
Get a recording problem
on a mortgage.
Oh man!
And the government needs to build a railroad over that property. You know, it's like.
Right.
So now we got an easement problem. Yeah, I used to hate those problems.
Kilo, now it's a taking.
That's way too funny. This is the nature of bi humor.
This is what lawyers think is funny, by the way, guys. Lawyers think this is hilarious.
True. It's fun. This is actually pretty fun. In fact, I'm a little bit slightly envious that Kurt is starting to study for a bar exam. There's a part of me that has kind of wondered for the last year or so if I should study for a bar exam somewhere just to brush up on stuff. And I've been thinking for a while about getting licensed in Virginia, and now this whole segue into the Johnny Depp trial. Which is happening in Virginia.
As a 15-year member of the Virginia bar, when you register, I'm going to have to file an opposition unsuitable for practice.
But why Virginia though? What's so special about Virginia? Does that get you some special powers, or what's going on?
Well, so I'm licensed in California and DC.
Yeah,
and
unfortunately, yes.
So and so for me. When we do eventually go back to the DC area, because that's likely when we do go back to the States, that's probably where we'll end up going. It would make, potential job prospects more open if I wanted to look for a firm job. At this point, I'm very much invested in doing other things.
As long as you're at it, why are you doing,
really? You don't want to work.
Too?
You don't want to work for a firm 90 hours a week? Wow, that's shocking. Oh my God! Wow, holy shit.
No, I don't. Just kill my soul slowly, day by day.
I literally don't even think about that. Doesn't ever cross my
mind. But it's one of those things that's like, yeah, maybe that would be kind of, maybe interesting, and then also to make sure that I'm up to speed on a lot of those basic bar questions.
I wonder if Virginia still has that mandatory, so you're a brand new lawyer in Virginia bullshit CLE that you have to do when you're brand new, and you have to go in person and have a powwow with the other new lawyers. That was an interesting one. And then I got into a disagreement with a girl who was going to be a clerk for Chief Justice Roberts about an ethics issue, and so we had a fight. It was fun.
Kurt fighting with people? So weird. Oh my gosh. Never
unheard of. That's really off brand for you.
Uncharacter.
Ella, thank you so much for your super chat. She says, my husband was in the USMC, graduated boot camp September 9th, 2001. Can't make that S up. That's insane. I'm sure he has some crazy stories.
I don't know. Why is that date significant? Anything around that time frame that would be
I don't know what
notable?
happened. I don't know what happened.
I think I've forgotten what. Yeah.
Jeez Louise. I'm sure he's got some crazy stories from his service. And thank you to you for I don't know if you guys were married while he was in the Marines, but I understand that life. A lot of people understand that life. There are some really great things about it, and there are some challenges that come with it too. So awesome. C Goody says, "Fine, I'll give you a follow on Twitter if you're gonna beg for it." Sheesh. All right, cool. I'll take it. Thanks.
Did he grift his way into your mods? Because he grifted his way into my mods hard.
I talked about this earlier. He had been a mod. And it was a little bit of a I guess controversial.
He was also a mod of mine at one point, and it's not for comparable reasons.
Okay.
All right.
So you're not alone.
Anyhow, well, he's got a strong sense of humor, I should say.
Yeah.
That's how I choose to characterize it.
I love my strong senses of humor.
Oh, of course, but you know, it's different. It's different.
No, you and Joe Neerman were you're just a dynamic duo. I'm like, this is great. I literally broke out the popcorn.
Did you hear about herpes? Did you guys hear about herpes? No, let's not talk about
herpes.
That
yeah, they're all spreading around.
This is what happens when you put me and Joe Neerman in a stream together. It just goes off the freaking rails.
Anyhow, so
by the way, Legalbytes. Everyone thinks I'm Lithuanian now. Everyone in my chat, they're like, "Oh, I'm so glad to hear you're Lithuanian." I've had 3 separate people. I'm like, "When have I said I'm Lithuanian?" Lithuanian roommate. I guess I know you. Does that make me Lithuanian? Like,
you look like you could be Lithuanian.
Do I?
Yeah.
I'll take that as a compliment. Yeah. They got a good basketball team.
Absolutely. Heck yeah, they do. A lot of great basketball stars coming out of there.
Yeah.
So anyhow, let's talk about Johnny Depp. Are you guys up on that? Because I have recently fallen down this rabbit hole, and it's new, but it's not new, right? It's been going on for actually a very long time, but there's actually trial scheduled in Virginia in Fairfax County Court next month, in almost exactly a month from today, a month from tomorrow, actually. So anyhow, the case is him against Amber Heard for her Washington Post op-ed, where she talks about being a domestic violence victim survivor, and how she kind of details in oblique ways that sort of references, like, I'm not talking about him, but I'm talking about him. And so as a result of that, he instantly lost his roles coming up for, well, one of the roles he lost as a result of a lawsuit that he filed against The Sun for basically the same thing. They had published an article calling him a wife beater for the same allegations based off of what Amber had said about him. Anyhow, so he lost his role in Fantastic Beasts. He lost his role for Pirates of the Caribbean, and so he's really kind of become blacklisted in Hollywood, all kinds of crazy stuff. So he filed. So she came out with that op-ed after having made those allegations way back in like 2016 in the midst of their divorce. In 2018, she published this article. And then in 2019, he filed a lawsuit. This was like 4 months later, because it was like end of 2018 and then early 2019. Anyhow, so they've been in litigation ever since then. And she filed counterclaims against him, basically saying everything that he said when he sat down with GQ and sat down with all these other people, and everything that his lawyer said to the press during the litigation against The Sun were all defamatory statements. So she had like a bunch of statements, like A through G, that were a bunch of different statements. The court ended up dismissing most of those, all but 3, basically. So the court said most of those are outside of the statute of limitations. Goodbye. So now there are 3 statements that she says in her counterclaims that are defamatory, and they're all by his attorney at the time that was representing him for the Sun litigation. And they're all statements where he's characterizing the lawsuit as or her charges or her allegations against him as a hoax. They're fake. There's like it's all incorrect. It's all wrong, and the evidence is going to come out, and it's all going to bring everything to light. So anyhow, there was a motion for summary judgment that was filed at the end of February, and I just yesterday on my channel I went through the entire thing and kind of went point by point through all of his arguments. And I think it's going to be really, really interesting to see if they manage to get her counterclaims dismissed, because to me, the statements that were made in that one, that are the subject of her claims. Well, the statements were actually made. They're published in articles, like they're published in the Daily Mail. And I mean, these are articles that were, or somebody was reporting on the actual litigation, and they talked to the Sun's lawyers, and then they talked to, I think, Amber Heard's lawyers, and then they talked to Johnny Depp's lawyers to get their statements on the case. And so they're all talking about this litigation. And it's very, very interesting to me, because all three of the statements that are at issue here are like that. They were all by Adam Waldman, Johnny Depp's attorney. None of them were actually by Johnny Depp himself. So the basic arguments in the motions for summary judgment are that the claim should be dismissed because there's no evidence that he conspired or directed Waldman to say these things, and that also that she has no evidence of actual malice by Adam Waldman. Because, of course, when we are talking about defamation and we're talking about defamation attributed to a third party, first off, you have to have that initial person that made the statement. You have to show that they are liable for defamation. And then on top of that you can attribute it to the other person. And then the third argument that they have is that the statements that he made are non-actionable opinions. But it was interesting to me because even though all of these are in the context of this lawsuit against the Sun, none of the arguments in the motion for summary judgment had anything to do with litigation privilege. So I don't know. Do you guys have any initial thoughts on that before I go more into detail? Because I know I've been talking for a while.
No, I mean, I'm always wondering because I mean, it's new information to me. I mean, did you have a way when you were leaning on the summary judgment? Did you have a way you thought, based on your read and your experience with it, the way it would come out necessarily? Or, I mean, did you have a prediction you made, or did you just kind of just read through the arguments?
Well, I think so. So basically they pointed to an interrogatory where they asked for all of the evidence that she has, that basically, goes to her damages for her defamation claims. Maybe not specifically damages, but basically the evidence that she has for her defamation claims. And then the response that she gave was like, Ms. Heard will provide a substantive response, which is of course a non-response. So, and that to me is just as a litigator was like, that's very frustrating. I always hate getting that kind of a response. But in this kind of a situation, the pressure is actually on Amber Heard to actually provide a substantive response, because that evidence goes to something that she has to show. And so when we're talking about a motion for summary judgment, the standard is that the court can dismiss the claims or the action or whatever if there are no genuine issues as to a material fact. Now, in this case, I think that probably the strongest argument of the three is probably the actual malice one, because we're talking about an attorney representing his client. And in order to show actual malice, you have to show that either he knew that what he was saying was false, or he had he had reckless disregard as to the truth or falsity of the statement, right?
For the attorney?
Yeah, for Waldman, right? That's his name?
Yeah, Waldman.
Yeah, I'm looking at the summary judgment now.
My obvious first question is litigation privilege.
Right. That's what I was saying.
That's that's a more preliminary problem. I'm not saying that you can't get around that problem, but that's that's like when you say the attorney, I'm like, wait a second. Well, where's the first problem? The first problem is litigation privilege. What you say in official court filings is protected.
It's funny because on civil they don't structure it that way. Maybe it's strategic, but they structure it in the summary judgment. I'm looking at it as the last argument. So like the protected opinion argument is the last one they make, which whatever. I mean, at least they're making it. Like it's but I agree with you. I think of that right away. Like that pops right into my mind.
Yeah. That was my first thought as well.
I mean, I just think that's a really strong motion. That's really strong points for this summary judgment motion. So, I mean, I don't think it looks good for Amber here, especially once again, trying to prove actual malice is so damn hard. It's so difficult.
Yeah.
I mean, when we get it, the whole point is when we get it, it's a huge thing. When these cases like with Veritas and the New York Times, where there's potential for actual malice, it's like, holy shit, this is a huge thing.
Yeah, it's a big deal. It's a big deal to get past that.
Yeah.
It was a big deal in the Kim Kardashian case.
And with who was the one with the
Cardi
STDs?
B.
Cardi B.
Yeah, Cardi.
Sorry. Cardi B is the one I was looking for.
I didn't want to misquote here. I didn't want to say
person.
Lizzo or somebody else. I'm confused them all.
Cardi B, Kim Kardashian, they're all the same. That's all.
I'm not gonna.
Well,
I don't want to get Legalbytes in a lawsuit here, so I'm not going to say any more because I don't. Cardi B's listening. Cardi's listening.
Of course, Cardi B is a regular listener of our.
Yeah,
of
she subs.
So
in that case, I apologize.
And in this kind of a situation, I think it's important for people to note, because you have two people that are claiming that have defamation claims here. You've got Johnny's initial claims against Amber, and now Amber's counterclaims against not exactly Johnny, but kind of Johnny, trying to attribute to Johnny statements that were made by somebody else. Both of them, because they are both public figures, they both have to show actual malice in the defamatory statements. Now, the reason why it's a slightly different analysis for the two of them is that she's alleging that Johnny Depp is liable for a statement made by somebody else about her. And it's like you've got like a central figure, and then somebody right here. Yeah, they've got a degree of separation. And so anytime you're talking about somebody else that's basing off of information that somebody else gave them, if they have a decent reason to believe that what they're saying is true and correct, there's no actual malice. Yes. But now if we are talking about the two central people that were involved in these situations, then somebody who's saying this happened to me, this did not happen to me, you're going to know if it's true or not. So actual malice is a little bit easier. Well, okay, of course, because there's possibilities of, substances, alcohol, drugs being involved. Consciousness, that kind of stuff. Hey, Nate.
And also false memories is not an inconsequential problem for everyone. You can fully believe something happened that never happened, or misbelieve it.
Perceive it a different way. You could say, hey, this happened in a certain way. Which
basically people as eyewitnesses kind of suck, and the evidence for that is legendary. It's like, where do you want to start? Which study,
Yeah.
People suck. Oh man. So Nate, did you have any take on Amber and Johnny?
No, except I've always had a huge crush on Amber Heard, but now since I found out she's crazy, until I found out she's crazy.
That hot crazy scale, there's a limit, baby. There's a limit.
I like crazy though. I like crazy though. That's the problem. Nate. She's being crazy makes me even more attracted to her. Like, oh my God, I like that crazy ass. But
I understand, but Nate.
I liked her in Aquaman, but it's
she's the reason for half the returns. It was her and Jason Momoa. That was it.
Was it? But she won. Didn't she win in England?
Nate, you think that means something?
So
she won in England, and
she wasn't. So she was not a party to the litigation in the UK case. It was Johnny Depp against The Sun for an article that they wrote about it. So again, we're talking about not the two central figures that are involved in these incidents. We're talking about a degree of separation. And this is also, it's a bit more difficult to find liability for a newspaper, for example, that is basing their article off of some kind of sources. If they have any reasonable basis for writing what they're writing about a public figure, to say like, hey, we talked to this person, and this person, and these sources said this, so we have every reason to believe it, then they're not going to be held liable for against the public figure, because there's no actual malice.
Yeah, I agree.
So that's that. And I will say that I know that there are a lot of people that have been really living this case for years, or living these two cases for years, and they know the details very inside and out. And I will say that I haven't had a chance to really dig into that UK case and everything that went down, but that's basically if that were to happen in the United States, that's the way that lawsuit would have gone down. It probably would have been a similar result, even regardless of whatever legal differences there are between here and the UK.
Which are notable when it comes to libel law.
Yes.
Yeah.
Yes.
UK
yeah,
sucks.
I think it's even more difficult just as a general matter to find defamation in the UK, I think, right?
It's easier.
No, it's easier in the UK.
It's
a lot easier in the UK. Yeah.
Okay.
Yeah.
Anyhow.
They needed to bring it in the courtroom so people weren't challenging each other to duels.
Duels are fine. Let's bring back dueling. That's how
I'm actually okay with it. R.I.P. Hamilton, but
Aaron Burr, right?
Aaron Burr, yep.
Dueling solves problems, right?
Mm-hmm, mm-hmm.
So, but anyhow, so the actual
duel for Devin, that'd be good.
Anyhow, so the motion for summary judgment was filed at the end of February. There's a little bit of time before Amber Heard's attorneys have their deadline to respond. I think it's on like March 17th or something. So I'm excited to see if that comes out onto the internet and that can be analyzed and digested and see ultimately what their arguments are, because I don't, if there's literally no discovery, because her response was like, oh, we'll answer at some point. We'll give some kind of answer at some point, and then didn't actually have anything, then that's going to be a really difficult kind of response to make in objection to that motion. So anyhow, but I'm getting super into this case, and I know that the trial is going to be going on next month, and it looks like it's going to be made public. So
really,
yes,
stream.
So it's going to be here.
You're dibsing it. You're dibsing it. You're dibsing it. Okay.
Dibs.
Yeah, you're dibsing it. All right. I
tapped.
Oh, it's me. Not it.
I'm definitely into that one. Yeah.
Yeah. That's really fun.
That's
it's gonna be super interesting. And even if it's not, I already decided that even if for some reason there's no live feed for it,
you're gonna have great thumbnails. You're gonna have great everything. You can swag it out. You can come up with memes. There's so much infinite possibility, even out of a boring trial. You know how much Pirates of the Caribbean is gonna circulate here. You're gonna
this is great. No, I love it. You could even borrow the theme music. I love it. Let Disney sue us for the copyright infringement. Bring it,
whoa. Do not poke the mouse. Have you seen what have you seen what Chapek is willing to say about bills he has no fucking idea about in Florida? I mean,
yes,
talk about bad.
I've seen Governor DeSantis' response, which are badass.
Yeah,
I just love the simplicity of his response when they start talking about it, and they're like, "Well, it infringes whatever," and he's like, "Against who? Against who?" And the reporter won't answer the question, so he just gives the answer. K to 3 or K to 3. That's what we're talking about, you assholes. Get it right.
Disney, they are taking no wins right now.
Oh boy.
I feel.
Oh yeah, sorry. You're gonna say, Nate?
No, I was just saying you can't feel sorry for Disney.
I don't. I'm
put out a Star Wars movie and they make another $1 billion. You see all this Disney merch I got behind me.
Yeah,
so. and we'll go and watch it, because we're
losers. We can't free ourselves from the mouth.
It's like Brokeback Disney. It's like, I just can't quit you.
I can't.
I never actually saw Brokeback Mountain, but
gotcha.
I saw it. It's actually a pretty good movie.
Now you're gonna have to. You're gonna be like, I need to get this meme. I need to understand the internet.
Oh man. So,
but I'm looking forward to whatever this trial is.
Yes.
And I hope the truth will out, and I hope the truth is based, because I think the truth is based. I think the truth is based, and I think that Amber Heard will be exposed. And I think it will just pour upon me like a molasses in its viscosity.
Hold on.
Cover me in almost an amber.
Isn't she Australian? So beautiful. Shouldn't it be Marmite?
No, she's from Austin, Texas.
Really?
Yeah.
Cover me in Terry Black's barbecue sauce.
Yeah, there you go.
Yeah.
Yep. There you go.
Terry Black's, and and it will just, the drippings are so sweet and so rich and so pure, and I will love every minute of it. Yum.
So I will say
meme Kurt guys with that one.
As I've been digging into it, I'm trying to keep my objective hat on, but I do have to say that what I've learned so far is telling me that she probably has been lying about
guilty.
A lot.
Come on.
Oh, yeah.
I said she's
you just figured that.
This is, I did the same thing at the beginning of the Alec Baldwin situation. I was like, okay, we're going to be as objective as possible. I have my opinions about him based on other things that he said and done in the past, but but
is that the fridge?
Yeah, I moved.
Did you just open the fridge? That doesn't have a refrigerator door. That looks like That looks like a cabinet door.
No, it's my fridge. Ta-da.
Oh, wow.
Yeah, no, I got. This made it too easy. I don't even have to get off stream to get drinks anymore.
Don't tell me you're sitting on the toilet too.
Actually, that's the thing.
Don't look down. Don't look down. Don't look down. Don't look down.
What's that sound of streaming water? Do you have a leak somewhere?
Oh man. So people, people might think that Legal Mindset moved from the bathroom to the kitchen, but he actually just moved a refrigerator.
I moved the kitchen to the bathroom. Yeah. By the way, shout out to Legalbytes who started the bathroom memes. I do appreciate that she made it a thing. So
I've got to give credit where it's really due, and that was Mr. Bites. He was the one that really brought it up, and it was because he's lived in Korea before. He understands.
Oh, he knows where we have our bathroom parties. Yes, got it.
Exactly. So anyhow, but I was gonna say, so even if for some crazy reason there isn't a live feed of the trial and I can't live stream it, I will, so be it. I will get my butt into the courtroom in Virginia, and I'll pull a Joe Neerman and do that and actually go and observe trial.
This could be fun.
I like the man on the ground reporting. I think it's really cool. I mean,
as a member of the Virginia bar, let me tell you what's really happening.
If you get a top hat and do that, it's uncivil. I will get you.
You need a monocle too.
Top of the morning to you.
I'm gonna get a full damn morning coat. We're going hardcore aristocrat. Yeah. I'll have the tails. Right. It'll be great.
Suck It says nothing is worse than Emily's mods. The worst.
Emily's mods are tough.
Emily's mods are tough. Emily's mods have banned me from the chat. I am banned in Emily's chat. All right, is anyone else here banned in Emily's chat?
I am not, but I'm
still good.
To be honest, I
may have been a little bit
catch
trolly.
Too many of her live streams during the lives.
I may have been a little bit trolly in the past, and I may have been pushing the boundaries, and the mods are really not. Yeah, it's possible. It's possible I may have been pushing the limits of
civility.
No, but they are. I've been
banned.
They are a very tough crew because they have some very specific standards and they make them very, very clear.
I thought the standards didn't apply to me because I'm on civil law, and apparently I was wrong. I said, "Do you know who I am?" And they're like, "Yes, banned." I said,
"Damn it!" Oh man! And one more. Britt Cormier says, "Amber is crazy. When a woman drops deuces in bed, there is an issue."
That's true.
Oh man, never let her poop the bed. I'm just saying. Red flag.
So, as someone that takes care of 3 animals, all of different sizes, you can
wait.
You can tell.
Hold on. Is your husband one of those animals or not? Which one are you counting that? No, not counted.
No.
Okay.
I have this one. I have Indy right here, and I have 2 cats.
Okay. Let's be clear for the people.
I will just say, as someone who cleans up after all of them, you can tell whose is whose. You can tell based on the size. And a Yorkie, there's a different circumference than there is for a human, an adult human. I'll just say that.
So is Amber Heard a Yorkie, or where's she in this metaphor?
She claimed that it was her Yorkie that did it.
Oh,
apparently.
Oh yeah, that's not even close.
Yeah.
All right. Good luck with that, Amber. We're gonna go with some analysis. They're gonna bring in the evidence back.
Oh man.
That was a South Park episode. Yeah.
It's terrible.
Yeah, evidence back.
And Emily, if you're out there, I'm sorry, girl. Hey, give me another chance, girl. I promise to behave this time.
The gaslighting. You're pretty much Amber Heard right now. You're like, Johnny, I won't throw that thing at you. I won't punch you anymore, Johnny. It'll be okay this time. Oh man.
Let's talk about Dua Lipa. Have you guys
a little bit, yes, one? About this.
What is this? It sounds like Duolingo. What is going on here? Like, what is this?
Hold on.
Dua Lipa. Yes.
I actually have the video coming up, but go ahead. Explain it, Emily. I mean, I'm Emily. Explain it. I got Emily on the mind now.
That's okay. I'm not offended. She's awesome. You can call me Emily. That's fine. So this is Dua Lipa, the singer. You know, if you don't know her name, you probably know some of her songs.
I just looked up her song.
Yes, she's got some really big songs over the last few years that have really kind of gone big, we'll say. So she apparently in the last week or so got hit with not one but two copyright lawsuits over her song "Levitating," and both of them they're separate people, separate bands or songwriters or whatever. They claim that she copied her song basically like. Not word for word, but she copied the melody, the background progression, like that kind of stuff. I
have it right here if you guys want to hear it.
Yes.
Oh, I have that all queued up too. Okay. So what I was gonna say is I'm gonna share my screen, and there's a really great video by Adam Neely on YouTube. He's got a fantastic channel. He's really good. He's like a music theorist, and so he breaks down a lot of these kinds of cases. Like he's not a lawyer from what I understand, but he kind of talks about like, hey, this is what like this is what the industry kind of understands, because a lot of songs copy one another. There's no truly original song. Like I remember hearing that Prince specifically refuses to listen to anything other than his own music so that he doesn't get influenced by other music. I don't know if that's actually true. If that was true because he passed away. Yeah.
It would be very hard to not be influenced by anything at all, even on an unconscious level.
Right. Exactly. And that's what's really interesting about this case, because there is some content out there. I mean, there's a podcast where she and her producer were talking about the way producer or somebody that was like the whole process of making this specific song and how they collaborated together, with starting with chord progressions, and then she just kind of riffed and then sort of came up with the melody, and it was just something that she just kind of subconsciously was somewhere in the back of her brain. But anyhow, let's start with adding so that you guys can listen to the songs. So I'll just start the first like 10 seconds of this, and then I'll skip ahead a little bit.
Do these songs sound the same to you?
You guys hear it?
Dua Lipa.
So, do those two sound very similar?
Yeah, they sound similar.
Yeah.
They sound more they sound more similar than the Blurred Lines and what's his name and the Marvin Gaye song.
Yeah, I agree with that.
That decision was still bullshit.
Yeah, even when the judges on the appeals court says, we're not saying that it's a good ruling. We're just saying you didn't bring it to us right. Yeah, that decision was total BS.
Yeah. So based off of that, you would think that this is and this is kind of like basically what he says in his video, that you would think that this is probably copyright infringement. However, there are some major issues here. Number one is, so let's just kind of start with what somebody has to prove with a copyright claim. Mm-hmm. Now, in order to successfully show that that somebody has violated your copyright, number one, you have to show that you own a valid copyright in the material. Number two, you have to show that the defendant copied the protected elements of the copyrighted work. So the parts that are at issue here, were they the ones that truly made this? Can they truly claim ownership in the copyright, or did they maybe get it from somebody else? That's one question. Number two is if they can even show that Dua Lipa even heard their music to begin with. Because if they've never come across their music, how could she possibly have copied this band's song if she's never even heard it? So one of the issues here is that this is there's two different cases kind of focusing on this video in particular focuses on the Article Sound System case, where this is a Florida reggae band that's kind of it seems kind of small and obscure.
Already starts sketchy. Yeah, I'm like, where are they playing? Like in Pensacola? Like they got 2 people in a bar. I mean, what do we got here? You know,
they have an album. They got an album, but they're nothing. But the one thing I always find fascinating about these cases is that it's to prove this, you have to prove first. In the past, most copyright cases for music, you're really only dealing with 2 things: melody and lyrics, right? If the melody and lyrics are the same, and then generally, the court doesn't really even listen to this music. They look at the sheet music, right? The sheet music is the same, and then the lyrics the same, and that's kind of how they do. So here now, with the newer cases that have been coming through with copyright, they've been actually listening to the music, and that's kind of how Blurred Lines got caught up there, because they were like, well, hold on, listening to the music is a style. For people don't know. Blurred Lines, the reason why most copyright experts think Blurred Lines was wrongfully decided is because they gave them a copyright protection on the style of the music, right? That there was a style. None of the lyrics were the same. None of the melodies were the same. Nothing that generally would win you a copyright claim except for style. So the Ninth Circuit essentially said you can copyright style. So I think in any type of instance, where's this at? California? Where's this case at?
This is so this particular case is in California. The other one is in New York.
So under the Ninth Circuit, because that's where the Blurred Lines case is, under the Ninth Circuit precedent, you also have to look at style too. So you're looking at melody, you're looking at this. And so I think Adam, he's right. And like I watched his video and I think he's right in that aspect. But you still have to now add Blurred Lines' style piece to it. And if you can say the style of this one matches this one, then you have something a little bit more. And that's what they're going to do in this courtroom. They're going to say, listen to these songs. Do they sound similar? And I think it's not as easy as I think most of the musical people are trying to make it seem.
Yeah, no, I think so too. And the other problem is if we're gonna take a look at substantial similarities here, let's check out this part of the video.
Not the first to do this kind of melody. In fact, the more damning evidence comes from an even earlier song, Outkast's 1988 song,
Rosa Parks.
Yeah, it's the same beat.
Same melody.
This is a jam. I love this one.
It's the exact same melody with the Charleston rhythm, outlining scale degrees 5, 4, 4, 4 at the same tempo. If you adjust for the key, it's exactly the same song as both Live Your Life and Levitating.
So, yeah.
And this way it plays them all 3 together, yeah.
Yeah. Oh, here, I'll play a little longer. A little bit longer. Same thing.
Now together. 3.
Yep. I mean, it's kind of a nice
works,
matchup.
but the thing is, like, if it's a scheme that works musically, why wouldn't you use it? Why wouldn't you use it? And why should one particular band have a monopoly on that? I don't think they should.
Well, and especially because what we're talking about here is the particular, like the rhythm to it.
Yeah.
The particular rhythm to it is it's called the Charleston. Like it's common in all music that is of that 70s style. It comes from the 1970s. So it's so common that it has its own name. So how can you say that you own a copyright in something that has existed for a very long time and in fact is recognized
as a theme? Yeah.
Exactly.
Yeah, as a theme. Yeah. I know. I get it. It's like, you can't you can't put a copyright on steampunk or something else in general, something that's a general theme, right? If it's a specific,
you can. Blurred Lines. In Blurred Lines, it's the general general theme.
God damn it, Nate! I know it's dumb. It's dumb law. Okay, it's
Blurred Lines decision was just wrong.
I quit
law.
That's exactly what he said.
The Blurred Lines decision is best ignored.
He's best ignored. They're in the Ninth Circuit. The Ninth Circuit upheld that bullshit.
What else are you telling me? Tell me another one.
The Ninth Circuit upheld it. Yeah, that's what they said. Literally, the only thing they had the same in those songs were the people in the background clapping.
Some shit sometimes.
You're not wrong, but I hate that you're right, Nate. You're not wrong, but I hate that you're right.
If this is the First Circuit, I'd be like, yeah, you're right. But the Fourth Circuit, no. You got to look at the style, the groove of the music. If it's still this, like, what the hell are you talking about? The groove is still the same.
Oh man. Oh man.
And what apparently sunk that case was saying I was inspired by that. That was Robin Thicke's apparently major crime of saying I was inspired. It was an inspiration. And so that's the basis. I'm like, you have got to be kidding me.
You know what's interesting here is that Dua Lipa apparently has said that she was inspired by Outkast for her whole album.
She did. Yeah,
and as a lawyer,
if you're a lawyer in the music industry, my advice is never say you're inspired by anyone ever or like anyone ever because of blurred lines.
Divinely,
I don't like any other musicians. None of them inspire me in any way. Thanks.
I hate music. This is an act of hate. Yeah.
There's other artists. Never heard of them.
Oh man. Yeah. It's you should always claim that it was somehow divinely inspired out of nowhere, somewhere in the heavens.
I'm suing all y'all for having the idea of having a law-related YouTube show and discussing cases. You guys are definitely infringing on my original works that I created. This is dumb. Man. This is so dumb.
You're gonna be like the legal gatehouse troll. You know, you got to pay the troll toll to get into the legal grift hole. I don't know. It's always.
I had the idea of discussing law. No one had that idea before me ever. It's not like there's commentaries or things.
No one.
Like ever. Who's Blackstone? I don't ever heard of him.
You know what? I want to ask. I want to look at Adams to see if he did a breakdown of the blurred lines case too.
I think he did.
Probably. I would not be surprised. That was such a big deal.
Yeah, because every theorist said there's nothing similar. I mean, maybe I'm not sure if he said it, but everybody was like, "There's nothing similar." I don't know if they can win.
And then Roman Thicke got such shit during the Me Too movement because of the lyrics, but the lyrics are like expressing an idea that's expressed in other songs. Like I know I can't, but I want to. It's like, I mean, it's like, I hate the world. I just hate everybody. I hate all people. It's basically where we're going at this point.
Pretty black pill over there today on TV. Not gonna lie, man.
On that note, let's go to Super Chat.
I love you. I love you guys.
Thank you.
You guys are my friends.
Thank you. We appreciate it.
Me specifically, Kurt.
Artemis Treese, thanks so much for your super chat. They said, just like Nate's take about celeb backers, 1, not the first time, there is a pattern. 2, took advantage of the nation at war with every brother, sister, neighbor. 3, actively intend to own race to prison. Some BLM. This is referring to Jussie Smollett.
Oh, Juicy. Okay.
Yeah. Juicy. We talked about him earlier before you came on Legal Mindset.
I mean, I'm of the mind, and we'll get to it, I'm sure, when you stream, Nate, but not to steal any wind out of that, but I am of the mind that I want it to be maximum punishment, but realistically, I'm a realist. I know it won't be, but I think that it is abhorrent to try to send the nation into a race war and to divide and to hit us on that sensitive topic. Anybody who's grifting on that or attempting to do something on that scale is an abhorrent individual.
All right, hot take: who should get more time, Jussie Smollett or Kim Potter?
Jussie.
Well, one of them broke the law.
Well, one was convicted. Both of them were convicted.
Both of them were convicted.
One of them broke the law.
Because I'm going to tell you guys, that's what the race baiters are going to say.
I know.
Even though I agree 100%,
was full of shit. The Kim Potter verdict is full of shit.
I agree with you guys 100%. But the race baiters are going to say
you're right.
Killed somebody, and and you're saying that he should get more time than her. And I'm agreeing with you. She didn't break it. She shouldn't have been convicted. Her conviction is a atrocity of justice. But
on the legal system,
yes, but.
Should we explain to everyone mistake again? Should we explain that again like we haven't explained it 8,000 times already?
The judge explained it. You haven't explained it to the judge. You can listen to the judge. The judge explained why she should go
over why whoopsie is in fact actually a legal defense? Should we go over that basic principle?
Oh my God.
Law again?
But that shows you how crazy the law is.
Yeah.
So we're most of us believe he should get more time than she should get.
Yep.
And they're both convicted. Crazy.
Yep.
Yeah. And then Artemis Treese also followed up with Nate, expunged DUI unfortunately seems to be 1, 2, 3, 4 need to murder more. I'm not sure I understand that.
Yeah, I don't get it either.
I don't.
People don't understand that sometimes you can get these. You plead to something after a certain amount of time.
I think the idea is that repeat DUIs aren't treated severely enough. I think is what that post is trying to say, which I think it might be true in some situations. I mean, there are like people on like their 20th DUI who seem to get like nothing, and I wonder why. I understand some I understand justice should be tempered by mercy, but sometime around the 20th time of the DUI, I don't know, man. It's like
right.
Rick Cormier says, if people can now sue over groove and riffs, all metal bands are in trouble because Black Sabbath laid it all down first, but then Black Sabbath need to pay all the blues bands before them.
It's when do you stop? Are we going back to like freaking like cave music here? I mean, how far are we going to go back? I mean, it's going to get ridiculous.
Yeah, right. It's
true
because
that's maybe, or maybe some old school Celtic.
It all goes back to the church.
It really does.
The
church can claim ownership of everything.
It's kind of true for art just generally and sciences. For the first substantial part of human existences all goes back to the church. The church was the huge patron of the arts, sciences. Yep. So yeah, the Catholic Church basically owns everything, is the ultimate end conclusion of where this ends.
It all goes back to God.
Which is one of the reasons that Vatican City, I guess, has all the gold ever.
And a lot of art. A lot of art. Yeah, true.
Yeah. Amongst other things.
I'm not sure what you're getting at, but okay.
I'm gonna leave it there. I'm gonna leave it hanging.
All right. So then I think the last thing to talk about is the Maxwell juror.
Yes. I thought Joe Neerman did a really good job on his video. He did a really good job, really short video. And I was watching Emily D. Baker, and I didn't actually finish it. I don't know if she came to the ultimate same conclusion, because I watched about half of it. And I'm like, Joe got to the point. He did the point, the analysis, the conclusion, and he did it in like 10 minutes. And I'm like, yeah, this is exactly right. He did a really good job.
Okay, so I didn't watch his video because he said that he was going to be here, Joe.
No, yeah, he did a really good one.
Stood me up.
So there's a two-part test in the Second Circuit that you have to show that the juror lied, which is different than made a mistake. So you have to show the actual like intent to deceive. And then on top of that, you have to show that the actual answer would have been a basis for cause challenge.
Yeah.
And the way that seems to be interpreted in the Second Circuit is that as a matter of law, the judge would basically be compelled to issue a for cause dismissal. So you would have to show that if they had answered honestly, that answer would be essentially sufficient to dismiss the juror for cause, which it's not. It's not sufficient to dismiss the juror for cause. Depending on their further answers, and in the hearing, as Joe Neerman himself said, the judge went into extensive, apparently, questioning of the juror on this whole issue of can you be fair, can you be unbiased, were you fair, were you unbiased, and all the rest of it, and going to establish that record. And it's like, yes, I can be unbiased, I can be fair. So I think as a matter of law, and I think Joe Neerman is right, I don't think the Second Circuit has ever overturned a decision on this basis.
Oh, wow. And
I don't see it happening now either, because it seems like that even assuming the juror lied, even if you conclude factor number one, and the juror's a little cagey and his explanation doesn't quite make sense. Yeah. So I think you can conclude, okay, there's sufficient evidence to conclude it's a lie. Like, you don't need the criminal standard. We don't need beyond a reasonable doubt for this purpose, right? We don't need to get ourselves to that level for the purposes of a new trial. So we're on some lower standard, whatever it is. So like, okay, so the juror lied. But as that second factor, would it be a sufficient basis for a for-cause challenge? No, because at least according to the government's own motion, there were other jurors who had answered that, were questioned, like one or two follow-ups, and some of them apparently sat on the jury, if I understood the government's motion correctly. So if other jurors who had said, yes, I had some history, and then asked, were you fair? And those jurors sat, how can you possibly show the prejudice? So basically you're done. And it's the end of the analysis. So I thought Joe explained that all in like 10 minutes, and he did a very good job. In fact, I made a point of calling him and telling him I thought he did a good job. So
nice.
Very nice. Yeah. I don't have his number. He didn't give me his number.
Yeah.
Just ask him.
That's true. You could just ask him.
Yeah. So I think we're done. I think the analysis has got to be, what the judge concludes on factor one, who can say? Because the judge is basically the finder of fact in this realm, and it's up to the judge, who actually got the benefit of actually, witnessing the juror testifying, which none of us did. So whether the judge concludes that this was a lie or not on factor one, who can say? But as to factor two, I think we're done. And so, yeah, there's
interesting.
Well, hold on, you mean elements? Because even if you lose factors, usually
if you lose factor one, you're in factor two, and I don't see how the Second Circuit reverses based on this record.
So hold on,
seems impossible.
So just to be clear, because all right, maybe it's just a thing with the terminology. When you say factor, I'm assuming factors of weight. So you can satisfy one factor and then you can not satisfy the second
elements
factor and still win. So are you talking about elements or
elements?
Factors?
Let's go elements instead of factors.
I'm asking. I don't know.
Yeah, I apologize.
Because factors you could satisfy the
imply
first
weighting.
one.
Yeah,
yes.
I wasn't implying weighting. No, elements.
Let's go elements. All right.
Two elements are required. And if you have element number 1, yeah, you don't have element number 2.
You're the one taking the bar, man. I'm just helping you out.
No, hey, you're right. No fault. No fault. Factor does imply a balancing test. You are correct.
Listen,
guys, in our words is always helpful.
I have to run real quick before 2:00, but
okay,
I will definitely see you guys at 2. Link is there later to the chat, even though I'm just very distrustful of the chat. And see Goody. I might model on my thing. I like
that. You lose one, you gain one, right?
Right.
Good. All right. So interesting, because Emily Baker thinks that they might actually.
Yeah, and also for what it's worth, the as I understand it, and would make total logical sense, the entire inquiry was very limited to the nature of the voir dire. Right. So what the juror may or may not have said during deliberations was not open for inquiry, which makes total logical sense.
Only during voir dire.
It makes total logical sense, because this is not like extrinsic things being brought into the case. It's not someone consulted the Bible or a Ouija board or something like that, which has happened in cases. Or something like that. So it's not extrinsic coming in. It's the juror himself coming in with whatever his experience is. So we're not going to ask, we're not getting into who said what in the jury deliberation. We're just asking this question about this voir dire, and that's where we're limited to. And so it seems to be right. I think Joe's analysis seemed right to me.
Yeah, that sounds right. Listening to it, listening to your analysis right there as a summary of a summary, it sounds good. I don't see an issue with that. Trying to look beyond that and see how you feel about it, or because, you feel a certain way about it is distinct from, hey, this is the legal analysis. It is limited to this. And that's the application of the law. And if that is indeed true, then that's the only way it could come out.
Now, I suppose there's a lot of discretion here, as we all know, for the trial judge, because abuse of discretion, as we all appreciate, is a pretty wide standard. So assuming the judge goes the other way and says, I'm going to order a new trial, and assuming the U.S. attorney appeals, that would be an interesting appeal, because, as I say, I don't think the Second Circuit has ever done this, but I don't know
that they won't.
Doesn't mean that they won't. And so, if it would be an abuse of discretion, is a legally hard trigger for the Court of Appeal. It should be for the Court of Appeals to do. So who knows? But we will follow it and see what the trial judge does. But I think if the trial judge says no, I think we're done. I think if the trial judge says yes, it could get interesting. But yeah.
I'm done with it, because every time you talk about Maxwell, it dings you in the algorithm. I hate literally just by bringing up Maxwell or Epstein.
Also, Jeffrey Epstein didn't kill himself.
Oh boy.
No, there we go. It's over. You know what? You're just really trying to tank Alita today. You're just like, you know what? We're bringing all the big guns out.
He just doesn't like the fact that I'm one of the only law tubers that has never gotten a strike or a warning.
It's because you just apologize very nicely to them and send you tea from your victorious competitions. Because secretly you bought it all. That's how she won. She bought it all for herself.
My mom did. Okay.
Oh, there we go. Your mom's got this giant dragon's hoard of dragon treasure tea.
Exactly. Anyway, let's get this one super chat here.
Oh my God. Look, guys, they're too busy. They are too busy right now simping for Ukraine. They got the little Ukraine stuff on OnlyFans, but they did let the Russian girls back in. So they are not starving. They are working girls. They're still working. I support them. And I don't judge anybody for their choice of occupation. They're freely allowed to do that as much as they want. I judge
the Sims.
And for anyone,
I judge the Sims. That's different. But the people doing the job, I don't judge.
And for anyone that's listening on the podcast version, Andrew is responding to a super chat from Phil Abudi, who says, Andrew, can you copyright throat songs by the OnlyFans thoughts?
Hearing you read it, it's worth the $5 super chat.
No, I didn't know that there were a lot of
Alita awkwardly reads super chats. That's
I didn't know there were a lot of Mongolian throat singers among the OnlyFans thoughts, but hey, Let's go. That's fine.
Yeah. Okay.
And C Goody says, that's it. Since you won't stop calling it LawTube, I'm starting a guerrilla campaign to get the name Lawtus officially recognized. Oh, and I'm suing.
Lawtus isn't doing it for me.
Lawtus is not going to happen. It is not going to happen. It's like
stop trying to make
fetch
it happen.
Yeah, it's not going to happen.
We looked for a combined name for a long time, and apparently we have, well, mostly because whoever, I guess it was Nick, changed the Twitter group name to LawTube. So apparently Nick has decided on behalf of the group. So,
he's like, it's been made. It's been done.
That debate's over, I guess.
Well, I think it didn't. I mean, it did. Like no one could really come to a consensus on anything else to call it, right? So it just kind of became like, well, I guess that's the default. And I don't know. I've been calling it that for somebody in the chat says law cells. Like incels.
LawTube is fine.
That's terrible. No, yeah. So like, I mean, I don't even think about it anymore. I just call it LawTube.
Flock of Legals is horrible. It's horrible. It's not gonna happen ever.
I've never. Yeah, it's the thing. The problem with Flock of Legals is that it
three syllables.
It takes too long.
2 syllables. Yeah. It's 1 syllable too many. You get 2 syllables max. That's what you got.
Yeah.
Boom, boom. That's it.
Yeah.
Latifa, I kind of like that. Or Lafia.
Lafia. The Lafia. Actually, I kind of like that one too.
Lafia's good. Consigliere is the big problem there.
Actually, I think Eric Hunley did one of his thumbnails, Lafia, and it looked good. It was like the cool, it was pretty cool thumbnail.
Wait, whose thumbnail?
I think Eric Hunley had a Lafia thumbnail.
Oh yes, yeah, that was good.
That was
really good. Scott Bain says Legalbytes hair back to being unbraided.
Whoa.
Sorry, Nick's unbraided meme is contagious. He says.
You gotta go deeper. Unbraided.
Yeah.
I didn't know you braided your hair. Did you?
There have been a few live streams where I've had kind of a sort of a side braid, sort of.
A side braid.
Yeah. Just
all right.
yeah. And I don't know. I guess people appreciate it. Maybe they like me having my hair down more. I don't know. And Hunch the Dirty Roofer says Barristers Roundtable.
Sounds a little pompous.
Too long. A little too long.
Yeah, it sounds like we're trying to be King Arthur here, like
King
fucking and my axe. Like we're doing some Lord of the Rings shit.
Can you imagine?
It reminds me of the McLaughlin group for some reason. That's what I think of when I think Barristers Roundtable, just like that scene or that setting. It's like, I'm like, I don't know, man. It's
I mean, but can you imagine Nick Rekieta being like, yes, we are the Barristers Roundtable.
That's the D&D session. That's LARPing at some point. You cannot I can't take that seriously.
When are we doing a D&D for the LawTubes? When are we doing it? We got to do one. We got to do some role playing. We got to have
actual.
Who's the best singer? Because someone actually has to be the bard.
I'm the best singer. The songs. I'm the best singer.
Are you sure?
I want to swing.
Oh God! I'm already triggered. I'm triggered. Also, Law Nerd Clips, please clip this.
Actually, I have a clips guy.
Sorry. Oh, sorry. I gripped the wrong channel.
Civil Bard is
Legal
best
Bites clips, please.
Yeah, that's okay.
Too much grip. Overloading.
It's okay. Whatever. If we can have more. That one can be clipped by Law Nerds clips too. That's fine too. Only that specific one.
Only that. Nothing else. I give you permission.
And then Nick Naylor says, "Just call it Uncivil Law." Well, but then we're all appropriating Uncivil Law's channel.
Yeah, he ain't gonna allow that to happen.
Well, I do like the fact that you're all now subsidiaries of Uncivil Law, though. That's pretty attractive. Yeah, I make up for that.
Anyhow, okay, let's one more super chat and then that's it. And then we got to wrap this up. Genuine question from Phil Aboudi says, genuine question, can defense opening statement be delivered after the state closes?
Depends, is the right answer. Trial management is in the discretion of the trial court, and it is not unusual to allow that. You typically have to ask. The modern consensus, because this was a debate for a long time, like, is it better to let the state close its case before the defense does its opening? The modern consensus appears to be no. that you're better off, because the problem is if you wait, then all you have is the jury, all you have is the prosecutor's narrative, right? It's the prosecutors just sitting there with their narrative, and they're just giving their things in line in their narrative, and you can't really, I mean, you can sort of try to tell the story of your narrative, but the problem is the jury doesn't know what it is. They don't have a framing device to hang everything from. So you're hoping that like all this stuff that you're building, that once you build the framing device later, that they'll be able to attach everything. But the problem is it's kind of too late. So the overwhelming consensus, so yes, you probably can do this if you ask. The overwhelming consensus is that this is a bad plan, that it is much better to give it as soon as they're done, because you want to have the competing narrative there, so that all the evidence that you can hang it on the narrative that you're trying to do, so you can, you know, make sure that you are doing all that stuff. So possible with discretion of the court, they'll almost certainly allow you to. It's probably not recommended. That's the right answer.
Yeah, no, I definitely agree, because it's the benefit of starting with an opening is that you create sort of a narrative into which the jury will fit their facts that they collect, because number one, you want them to remember the facts. I mean, typically you want them to remember the good facts that are good for your case, and maybe not remember the bad facts for your case. But generally speaking, you want them to remember things, right? Because otherwise, like, if you want them to be able to weigh it. If they can't remember it, they can't weigh it in the jury room. Number two, you want them to remember it with the framing that benefits your client. So if you don't start off that way, exactly what Kurt said, like you're running the risk that the entire time that the jury is taking in the evidence put on during the prosecution's or the plaintiff's case in chief, then you're relying, or you're running the risk that they are doing that with the opposing side's narrative in mind. So, which, you know, it takes time for that to build up, and it might be too late by the time you start to introduce your own narrative instead.
Yeah, I mean, and statistically, they said that in terms of attention span, most people just listen to the opening statement is one of the things that's the most influential, that most people listen to. You can assure they're tuned in. They may be tuned out by even the closing. By the closing, they probably already made up their mind. They may make their mind up during the opening. But I guess the question is, could it still happen? Like, can it still happen? Like, is it possible for them to do that? And I mean, theoretically, it's possible. It's a horrible idea, but I guess in theory it's possible, right?
I agree. Scott Bain says prosecution, quote, rebuttal closing, unquote, should go away. Profoundly unfair. I don't think so.
Burden. It's supposed to balance out the burden. I mean, I see the point. I'm not a huge fan of it. I think that maybe the time could be more limited. Like we could say, okay, you get half the time on rebuttal. Like you can't have more time than they have. Like there's some sort of limitation on it. I'm okay with that, but I think the rebuttal is important.
Yeah. I think I do agree. I think that the way in which that becomes profoundly unfair is when judges don't enforce the timing of the rebuttal, because then it's like they just get a second closing argument. You know, if they're allowed to do, you know, to go on for however long they want to. So that's the situation. That
if I become a judge, we're having some time limits in my court. I'm telling you.
Oh, agreed. They're getting 45 fucking minutes max. Like that's pushing it.
For their closing, and then maybe I'll give them 30 for the rebuttal. 15. They get a solid hour. That's it. Then shut up and sit down.
Because the thing too is that like when your closing goes on for forever, there's not even a very high chance that the jury's even listening.
Do you think it's unduly prejudicial if we had unlimited time, and at some point I as a judge just pop in and be like, okay, you got to stop. I've lost the will to live. You guys, it's over now. Thanks for your commentary. Goodbye.
Yep.
Is that unduly prejudicial?
That might be.
Okay.
A little bit.
Although the judge in, oh God, which case was that? The Detroit judge, not Detroit, was it? The guy that looks like Jeremy Renner. Which case was that?
What?
The
Hawkeye?
Judge that looked, huh? Yeah.
Hawkeye?
Yeah. I feel like he would have made a comment.
That was B. Ivory Lamar. That was
B. Ivory. Yes. Okay.
That case. Yes.
Yes. The one where B. Ivory Lamar was one of the attorneys. I can't. For whatever reason.
Do you need more than 30 minutes for an opening? That's the real question.
No.
Because
Edgecombe. Thank you. Edgecombe.
You don't need that much time. That's the whole thing. Like, you don't need that much time. The whole point of the opening is just to frame. How much you don't the framing, the scaffolding. Like, how much time do you really need? Do you really need more than a half hour?
It depends on the case.
How much do you? Does it though?
It does. I think so. I think particularly complex matters. Yeah, you could do it, and I mean, I still think that you have a good point. That generally speaking, you still should try to keep it as short and to the point as possible, because no matter how complex the case is, people still
I need you to simplify the entire thing down in its scope, complexity, and length to like Thomas the Tank Engine. I need it to be a book, maybe with some pictures, pop-up pictures would be fine. I need you to simplify it way the fuck down.
Pictures must be 3D.
Yep.
For everyone's sanity, I need you to simplify this way the hell down.
Yeah, I mean, look, there you go. I mean, I think they give an hour for closing, and the prosecution gets to divide that up how they want. 45-15, 30-30. It's like you go over it. That's it. You're done.
Yeah.
A pop-up book as a jury device for a closing argument would be that'd be so cool.
Lovely.
Especially if
it's like a giant demonstrative.
A plaintiff in a personal injury case. Oh, that'd be so good.
But you know what's sad?
I do my whole closing, and I print an actual pop-up book. And they're like, okay, jury, I'm going to read you.
That's about at the education level of the average American jury.
Oh, this is the best
I don't know.
I don't
think you can.
I'm saying it. Put it on me. Put on Eagle.
I've got my new career. I'm becoming a plaintiff's lawyer, and my closings are going to be pop-up books. It's going to be fantastic. Here is Sam, the construction worker. Sam is getting ready for work. Here is the big rig truck. Big rig truck run over Sam. Sam is sad.
Sam is a paraplegic now and requires damages.
And then you're gonna get a bunch of jurors that are gonna look at you like you think I'm an idiot, and then they're gonna rule against you. So,
but I do think
they'd be like,
we've covered enough cases from enough jurors that I know they're idiots. And not even that. Like, we were having that debate with or discussion with. Who was it basically where I was just trying to argue some facts, and they're like, but that's not the way jurors work. And I'm like, but flowcharts though. And they're like, but no. I'm like, yeah, it was Ty Beard or Robert Barnes or someone just basically openly mocking me for trying to apply logic to something. And I was just losing horribly.
Yeah, I mean, there's emotionalism as part of this. I mean, we all are emotional creatures. We make a lot of our decisions based on emotion, not necessarily on facts and how we feel about it. And we may make a decision, and jurors certainly make a decision based on how they feel about the case. If they look at somebody and they find them, for example, untrustworthy, we actually expect them to rule against them because they're weighing the credibility and they're saying that's not a credible person. Like when Edgecombe got up there and started speaking in the Edgecombe trial, he was a horrible witness. He was completely incredible. And people saw that. We saw through it.
Yeah. Philip Booty says, you got 20 minutes. You go over, you lose. And Rolf Peterson says, brevity is the soul of wit. That is true. Very true.
I think that's a good place to end.
I think so too. I think because this has not been brief, but it has been wonderful. It has been so great. Thank you so much, you guys, for joining me. Thank you to everyone that is watching and that has been watching. Thank you to everybody in the chat, all the mods. Everybody. Thank you to Nate the lawyer who was here earlier. Thanks to Good Logic for not showing up today. I'm just kidding.
Hey, listen. It is 3:00 in the morning right now. If I can show up, it's always an accomplishment.
It's true. Yes. And thank you so much for being here. And okay, one last super chat and then that's it. Philip Booty
says,
stop
sending your money.
Stop sending me money.
Stop.
He says, and here we see the bad guy over there stabbing the victim. In and out, in and out, in and out. Here we see the blood gushing out. Ooh, it's red. Oh my goodness. That is terrible, but also kind of wonderful.
Your dark sense of humor, Alita.
All right. On that note, we are going to head out. Thank you so much to everybody for being here. Have a great day, and go watch the sentencing hearing on Nate's channel. I plan to be there. Actually, in like 5 minutes. There's a link in the description below, along with all the other
content. Click it, baby.
All right. Bye.